Article 3 of the U.S. Constitution established the United States Supreme Court. It is the highest court in the American judicial system, and it possesses immense power. It reviews cases under its appellate jurisdiction as they move up from the lower courts, and less frequently, it decides matters by its original jurisdiction. It even has the power to render null and void both state and federal legislation when those laws run afoul of the Constitution. That last concept falls under judicial review. However, the Constitution that created the court did not expressly grant that power to it. So the question arises, how did the court obtain what is arguably its most powerful tool? My name is Matthew Collum, and here on Law and History, we're going to examine the landmark case of Marbury v. Madison. We will see how it created judicial review and how that concept made the Supreme Court truly co-equal to the Congress and the presidency. Before we jump into the case itself, we need some historical background to provide some context to the court's decision. In 1800, President John Adams was running for re-election against his own Vice President, Thomas Jefferson. Both camps fought hard during this race. 4 years earlier, in 1796, Adams had narrowly defeated Jefferson, and in those days, the defeated presidential candidate served as the victorious president's VP. But this was not just a choice between two executives who really disliked each other. No, this was actually a clash between two political parties with hugely different ideas of what America should be. Not much has changed. On one hand, Adams' Federalist Party embraced a robust and centralized federal government. For instance, it was pro-business, it sought a strong military, and advocated for better relations with the British. On the other hand, Jefferson's Democratic Republicans advocated for a decentralized federal authority. They embraced state authority and distrusted centralized power of any stripe. They viewed the Federalists as elitists, as supporters as America's business aristocracy. They also favored France over Great Britain. Ultimately, in the elections of 1800, the Federalists lost both the presidency and the Congress to the Democratic Republicans. Now, at that time, presidential inaugurations took place in March following the election year, not in January as they do today. However, much like today, Adams realized that by controlling the courts, his outgoing party could continue to exert a tremendous amount of influence, even if they were no longer the dominant party in Congress nor re-elected to the presidency. Enter the so-called Midnight Judges. As late as early March 1801, just a few days before his term was to expire, Adams nominated and the Federalist-dominated Senate approved almost 60 judges to embed Federalist supporters into the federal judiciary. Now, among those named was Mr. William Marbury. Marbury lived in Annapolis. He was a successful financier and an ardent Federalist. Although not a judge, Adams appointed Marbury as a Justice of the Peace, which was a kind of judicial officer to preside in the District of Columbia. However, Adams' administration did not deliver Marbury's commission to him before the president's term ended. Chief Justice John Marshall, the justice who would write the opinion in Marbury v. Madison, was, until the very end of Adams' administration, also the Secretary of State. It was his office's responsibility to deliver those commissions, and he worked to do so until the very end of Adams' term. It is here where the facts of the case start to come into play. Thomas Jefferson and his Democratic Republicans took office on March 4th of 1801. Jefferson and his supporters were aghast at Adams' Midnight Judges, and they did everything they could to undo his actions. This included passing legislation that, for the purposes of this video, is somewhat beyond our scope. However, what is firmly within our wheelhouse is this. Jefferson's Secretary of State, James Madison, was legally bound to deliver Adams' signed commissions to the judicial officials Adams appointed, but who had not yet received their commissions. Now, this included Marbury's commission. Secretary Madison, however, in line with his boss's opinion on the whole matter, refused to deliver the commission, thus keeping Marbury from assuming his post. Now, later that year, later 1801, Marbury filed a lawsuit with the Supreme Court. He petitioned the court for a writ of mandamus to compel Secretary Madison to deliver his commission. Now, two things. One, you may be wondering what a writ of mandamus is, and two, you may also be wondering how it is that Marbury got his case into the Supreme Court without first petitioning a lower court. Well, let's answer both of those questions. A writ of mandamus is simply a legal mechanism compelling action. A petitioner can ask a court to compel someone, usually a government official, to complete some task or action that the official was already bound by the law to do. Now, they can do this by issuing that writ of mandamus. Importantly, Section 13 of the Judiciary Act of 1789 empowered the court to do just that. Now, we'll discuss that legislation in a little bit more detail a little later in the video. Section 13 is also what enabled Marbury to plead his case directly to the court in the first place. Section 13 granted the court the power to issue writs of mandamus and made them part of its original jurisdiction. Simply put, Section 13 enabled Marbury to petition the court for a writ, and it's why he did not have to first petition a lower court to have the case reviewed under its appellate jurisdiction. In 1803, the court took up Marbury's case. The 2-year delay was the product of Democratic-Republican political machination and back and forth in the Congress that sought to undo much of Adams and the Federalist moves regarding the judiciary. Chief Justice John Marshall, himself a Federalist, wrote the 26-page opinion identifying 3 issues for the court to consider. And I'll quote them directly. 1. Has the applicant a right to the commission he demanded? 2. If he has a right, and that right has been violated, do the laws of his country afford him a remedy? And lastly, 3. If they do afford him a remedy, is it a mandamus issuing from the court? Now, issues 1 and 2 were really stepping stones to answer the true issue Chief Justice Marshall had identified in the case. On its face, issue 3 concerned whether the court could issue the writ of mandamus Marbury sought, but a deeper reading of the case revealed a concern over jurisdiction and the constitutionality of Section 13. Without being too trite about it, the specifics surrounding the court's holdings regarding issues 1 and 2 aren't too terribly important to the legacy of Marbury v. Madison. The court's findings on those issues can be summed up as, yes, Marbury had both a legal right to the commission and U.S. law did provide a remedy for him. But it is in the court's reasoning and holding concerning issue 3 where we find why this case is so important. The court answered issue 3 by examining, in this one, 2 sub-issues. 1, whether a mandamus was the appropriate remedy, and 2, whether the court had the power to issue one. As to sub-issue 1, the court held that the most appropriate remedy under U.S. law was a writ of mandamus. Case law and historical precedent, both under English and American common law, supported that outcome. Now, sub-issue 2 concerned the power of the court to issue that writ of mandamus. Essentially, it considered whether the court could properly exercise that power. Article 3, Section 1 of the Constitution established the Supreme Court and empowered the Congress to create such inferior courts as may be necessary. Congress's Judiciary Act of 1789 built upon that constitutional foundation and established the lower courts comprising America's federal judiciary. As we said, Section 13 of the Act empowered the court to issue writs of mandamus. Chief Justice Marshall quoted that section in the opinion, stating that, quote, "The Judiciary Act of 1789 authorized the Supreme Court to issue writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States." However, despite this grant of power by the Congress, the court held that this congressional expansion of its powers had in fact exceeded the limits placed upon it by the Constitution. As we touched on, the provisions set forth in Article 3 of the Constitution established the court and permitted Congress to establish its lower courts if necessary. But it also enumerated the court's powers and delineated the court's original and appellate jurisdictions. Article 3, Section 2, Clause 2 of the Constitution expressly stated that, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. On this sub-issue, with regard to whether the court could in fact issue a writ of mandamus under its original jurisdiction, the court concluded that issuing that mandamus was only possible when the court addressed a case brought to it under its appellate jurisdiction. The Constitution had expressly stated to which subjects the court's original jurisdiction applied, and issuing a writ of mandamus was not one of them. And so, in effect, Section 13 of the 1789 Act stood in conflict with the Constitution's express provisions. The court, in one of the opinion's most famous passages, wrote that, quote, "It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If two laws conflict with each other, the court must decide on the operation of each. And to that end, the court did decide. It held that Section 13 of the 1789 Act was unconstitutional, and therefore null and void. It was repugnant to the Constitution. The philosophical argument that the Constitution was a written document and the source of all American law supported this reasoning. Congress could not simply pass legislation ignoring the Constitution's provisions, as it had when it conferred to the court the ability to issue writs of mandamus via Section 13 under its original jurisdiction. Although the opinion was clear that Marbury had every right to receive both his commission and the office to which Adams had appointed him, this holding had the effect of rendering Marbury's remedy impossible to issue. Marbury would never receive his commission, but the effect of this case were far larger than his unfortunate outcome. Judicial review solidified the court's authority in a way that even the Constitution itself had not expressly contemplated. Namely, the doctrine made the court the final arbiter as to what was and was not constitutional. Now, as we move forward in this series, we will see how this doctrine is expanded, and also how it underpinned some of the most momentous decisions in the court's history. To be clear, the concept did not completely emerge from a vacuum, okay? Alexander Hamilton seemed to have anticipated the doctrine in Federalist 78 and 81, and some state courts had infrequently exercised similar powers despite state legislature objections. Nonetheless, Marbury v. Madison laid the foundation for the court's most powerful tool and secured its position as a truly co-equal branch of government, able to nullify unconstitutional legislation and challenge unconstitutional actions. Historically, the decision also skirted the shoals of political disaster quite well. As we noted, Chief Justice Marshall was a Federalist and Jefferson a Democrat-Republican. Moreover, Marshall was Secretary of State when Marbury's commission was created but not delivered. There are all sorts of obvious conflicts of interest here. Regardless, however, in this opinion, Marshall was able to say that Marbury and the Federalists were within their rights, but also satisfied Jefferson and his party by rendering that fact null and void. Now, he did that by creating the doctrine of judicial review. At the same time, Jefferson could not criticize the decision nor its novel doctrine too loudly. Now, he couldn't do that because it had the effect of stymieing Federalist control in the courts and granting the outcome that he no doubt wanted. Marshall recognized the opportunity that existed then, and in taking it, he crafted the most powerful tool in the court's toolbox, judicial review. Now, as we said, from now on, the court would be truly co-equal to the Congress and the presidency because it had the power, at least in theory, to check their legislation and actions. All right, if you made it this far, thank you. Give the video a like, leave a comment, and subscribe to the channel. Be sure to check back often for more content. And have a nice day.